Having given
But
clear,
Mr. Mehta, it may be difficult to accept your submission that, look, federalism as a concept applies only where the union and the states. You know, there may be also a sense of hybrid federalism where, where even as between the union territory of Delhi and the state and the center, some elements of the federal structure also apply there. May not be to the same extent as in relation to a full-fledged state. But in carving out a constitutional amendment for the Union Territory of Delhi, that was also in reflection of a certain degree of federal aspiration. So you're right. I mean, it's obviously not a state. So, you know, it doesn't have all the trappings of a state, but it has some trappings of a state. So as to implicate federal concepts, even in the relationship between the center and the Union Territory.
May I rephrase my submission? Lord, the principle of federalism will not. Every argument, my lord, every submission and facts are there.
You put in your supplementary.
Yes, they are already there, but I have put it in a little flow so that it's, Lord, easier for me to assist your lordships, my lord.
So should we go through your because that is comprehensive. So should we go through your supplementary submission?
Correct.
Okay.
Correct. My lord,
supplementary.
Yes, my lord, I am putting a caveat.
That's why you got.
My lord.
This includes the previous one.
So, my lord, it is supplementary written submissions.
So therefore, you have taken into account the previous one and comprehensively made this.
Yes.
So this is sufficient. We don't need to go back to the previous one.
One or two legal submissions are new. Otherwise, my lord, they are all repetition, but we found at one place.
Right.
But there is one caveat. Lord, before I take your lordships to the legal submissions, Lord, I would confine to legal submissions only. My lord, why I say this? Lord, certain events are happening, my lord, when your lordships are in the midst of the matter. Some protests, etc., which, my lord, constitutional functionary should always avoid when the matter is before your lordship. I would not answer, but if your lordship would like to know the facts, Lord, we are open. But we thought, my lord, that we would confine to the legal and constitutional submissions, because protest or theatrics can never take place of written submissions before the constitution bench. If your lordship finds anything based on, my lord, some news articles being, my lord, recently published, my lord, it's a coincidence, must be a coincidence that since last 8 days some news articles are coming or some protest. Lord, if your lordship would like to know the facts, I'll be very happy to assist.
You can't decide a question of constitutional interpretation on the basis of...
Absolutely, my lord. By going into that, I don't wish to reduce...
the constitution.
I don't wish to reduce the level of debate before the highest court of the country, my lord, to anything. Because, my lord, whatever happens in the capital...
Dr. Singhvi, we have indicated that this is a constitutional issue.
I have, in fact, much more to say than he does. I have desisted completely. Therefore, where is the question for this initial
I am not against Dr. Singhvi.
So let's get
the level of not doing it.
All right. So we go on with your written submission and we look at the constitutional argument.
Yes, because, my lord, whatever happens in the capital is seen by the world, my lord, and it's an embarrassment for the entire nation. Therefore, I put a caveat. We have nothing to hide. We'll show if your lordship wishes to. Otherwise, I will go to the constitutional court. Now, Lord, coming to the services. Your lordships, on the last occasion, my lord, pose a very pertinent question, which is the heart of the matter. How do you involve or include services within the phrase of insofar as it is applicable to the union territories? So that was your lordship's question. And that's, my lord, precisely the question for consideration. Lord, firstly, and I'll take that, my lord, it is the assertion of NCT of Delhi that services falls within us, falls within them. It is for them to show under which provision services falls within them. Merely showing that it is in the state list, entry 41, and therefore applies to us, will not be a sufficient threshold crossing to decide whether services falls within them or not. They have not crossed that threshold, except giving some administrative difficulties, my lord, which cannot be a substitute for a constitutional argument whether this entry falls within union territory or the central government. So, my lord, while saying that they have not discharged their burden, Since I am before your lordships, it's my duty to satisfy the conscience of the court that constitutionally it lies with the center. Lord, first and foremost, Lord, we cannot forget. Lord, the argument was we could recall, Lord, since 2 days have passed. In fact, that there is a full-fledged state, there is a central government, and there is an intervention not permissible under the Constitution. Lord, my fundamental submission, based upon which, Lord, I'll make this submission is that we cannot lose sight of the fact that we are dealing with the capital of the nation, and central government is a major stakeholder in the administration of capital. It's not an intervention of an outsider.
But Mr. Solicitor, you will also still have to deal with the question as to whether recognizing the executive power of the GNCTD over services will detract from the status of Delhi as a national capital territory.
Certainly, I must do that. I must do that. But before that, my lord, I'll have to lay foundation from your lordship's judgment that Delhi has a sui generis character, and therefore it is a hybrid model which is chosen, that some powers are ceded by the center, though it remains a union territory.
Fair enough. Should we conclude the submission? Because then we can, as we go along, then you can break in the paragraph and then make your submission, so that
Please, Your Lordship.
your submissions have.
Lord, I would, my lord, earnestly urge your lordships to allow me to read some of the paragraphs from the 5-judge bench judgment.
You have quoted them also here.
Yes.
Of course, you can certainly read them.
Yes.
Like,
I'll not go beyond, my lord, what I have stated here. I can
so
assure.
let's read through it. It'll also give us a perspective. It'll
Lord,
sort of
the-
help us to.
Yes. My lord, the majority judgment, when I say majority judgment, my lord, numerical majority, because there was no minority.
Minority actually.
Yeah, so majority in the loose sense of the term, because there was no your lordships and my lord Justice Bhushan were concurring judgments. But majority does not deal with this crucial aspect, the significance
Of Delhi.
of capital. My lord, the Chief Justice, my lord, was pleased to deal with this, my lord, at page 2, para.
Why don't you read from para 1 onwards? Just read it. It will just help us to sort of sink into the matter,
Please,
because
please,
the
sir.
weekend has gone by.
I'm obliged, my lords. The entire argument proceeds as if the central government is interfering in the legislative and administrative field of a full-fledged state, thus violating the federal structure. The entire discussion of majority was in federal structure in a state center context. The significance of
One second. Supplementary.
Yes,
Today. Everyone.
Yes, please. Then,
Para 2. The significance of Delhi as a capital and its control by the state government is recognized. Lord, it should be central government. Lord, that's a typo. Para 2, page para 2, Lord, there is a typo, Lord. Significance of Delhi as a capital and its control by the state government. It should be central government. Your lordship would find that in the context subsequently, is recognized both prior to the constitution and after the constitution. But prior to, I have read, my lord, that the center must keep its control over the capital. Article 239AA is also so structured that while providing for a democratic government in the NCT of Delhi, the major control of the major stakeholder, that is the government of the entire nation, is retained over the capital of the country. The entire issue deserves to be viewed keeping this backdrop in mind. The entire discussion of the majority judgment on federalism, etc., misses this viewpoint, vital point in the entire discussion on federalism.
Mr. Solicitor, just do this as we go along. Tell your junior, the nodal counsel, Padmesh, who's been looking after this, to make whatever corrections, like state, center, or as you go along, you can do it on your laptop and mail it to the court master. So he'll immediately mail a correct copy.
Simultaneously. But subsequent para
No
makes
problem.
it clear that what I
He'll be able to do it right here, because as you are correcting as you go along, he can correct
Certainly,
it on
we
this.
shall do that. I am obliged. Under the title Federalism, Collaborative Federalism, Pragmatic Federalism, and Concept of Federalism and Balance are devoted to issues which can apply only to states. The concurring view, my lord, the Chief Justice, however, recognizes this concept in the judgment so and so. I'll read para 362. While bearing these fundamental constitutional principles of a democracy in mind, a balance has to be struck with the second of the above elements, which recognizes the special status of the NCT. The NCT represents the aspirations of the residents of its territory, but it embodies in its character as a capital city the political symbolism underlying national governance. The circumstances pertaining to the governance of NCT may have a direct and immediate impact upon the collective welfare of the nation. This is the rationale for the exclusion of the subject of public order, police and land from legislative power and necessarily from the executive power of the NCT. These considerations would necessarily require a careful balance between the two principles. Of the two principles must be given adequate weight, producing a result which promotes the basic constitutional value of participatory democracy, while at the same time preserving fundamental concerns in the secure governance of the nation. Then, my lords were pleased to indicate 389. Undoubtedly, the governance of NCT involves national imperatives. They must also weigh in the balance. The proviso to clause 4 of Article 239AA is constitutional indicator of the national concern which were borne in mind when the constituent power was exercised, established the NCT as a political arm of the governance by a special constitutional provision. Those national imperatives have led to the carving out of areas of police, public order and land from the sphere of legislative authority of the Legislative Assembly and their entrustment to the Parliament. But insofar as my lords have said somewhere else, it's not coming here. Again, it is the sense of national imperative which led to the constituent power being so modulated in relation to the NCT as to allow parliamentary legislative authority over all entries in the state list in addition to the concurrent list. Parliament does not exercise legislative authority in relation to the state list entries as regards the states in India unless a matter falls within the ambit of Article 252 or 253. Parliamentary legislative control over union territories has been broadened precisely as a manifestation of national imperatives or concerns. The executive power of the Council of Ministers being coextensive with the legislative power, this aspect has to be borne in mind. The true challenge is to maintain that delicate balance in a federating union such as ours, which ensures that national concerns are preserved in the interest of unity and integrity of the nation, while at the same time, local aspirations exercised through the democratic functioning of the elected government find expression in our polity. Then, my lords, the Chief Justice was pleased to observe in 390, the constitutional principle which emerges is that while Delhi presents a special case, quite unlike other union territories, the constitutional provisions governing it are an amalgam between national concerns reflected in control by the union and representative democracy expressed through the mandate of a council of ministers which owe collective responsibility to a directly elected legislature. There is no gainsaying the fact that the control by the union is also control of the president acting on the aid and advice of the Union Council of Ministers, which in turn owes collective responsibility to the parliament. Constitutional statesmanship between the two levels of governance, the center and the union territory, ought to ensure that practical issues are resolved with a sense of political maturity and administrative experience. This court has to step in only because skirmishes between the two have raised constitutional issues of proper distribution of executive control over national capital territory. In this context, what I said, from 92 till date, with a level of political maturity, though there were different political regimes in center and state, everything worked smooth. Then, my lords were pleased to say at 471, the exercise of the constituent power to introduce Article 239AA was cognizant of the necessity to protect national interests inherent in the governance of a national capital. A sense of permanence and stability was sought to be attributed to the arrangements made for governing Delhi by bringing in a constitutional amendment. both in terms of the reach of the legislative power as well as in relation to the exercise of executive power. The special constitutional arrangements for Delhi recognizes that the governance of Delhi implicates a sense of national interest. When matters of national interest arise, they would predicate a predominant role of institutions of national governance. Lord, then my Lord Justice Bhushan is pleased to devote one paragraph. The word capital is derived from Latin word caput, meaning head, and denotes a certain primacy status associated with the very idea of a capital. Delhi is the national capital of the country. For the purposes of this case, it is not necessary to notice early history of Delhi. During the British period, your lordships can skip the history your lordships have seen. Now, Lord, now I am coming directly how I respectfully assist your lordships that services are not applicable to union territories. So those phrases insofar as not applicable. Services vis-a-vis union territories. The Constitution of India very specifically demarcates units of governance of the nation. A perusal of the index would show that the following units of governance are contemplated by the Constitution and separate and specific powers, duties, responsibilities and provisions are made. Lord, Part 5 entirely devoted to the Union. Part 6 entirely devoted to states. And Part 8 entirely devoted to Union territories, which, my Lord, was introduced by 7th Amendment. The Part 8 was introduced by 7th Amendment. The above are the units of governance contemplated under the Constitution, all of which consist of elected representatives and have been given the legislative and corresponding executive powers depending upon the nature of the union. The union which is contemplated constitutionally and is contained in Part 5 of the Constitution represents the collective will of the entire nation, and therefore they have legislative and corresponding powers over both List 1 and List 3, subject to Article 245. The state which are contemplated constitutionally and is contained under Part 6 of the Constitution reflects the democratic will of only one state, and therefore only those subjects are conferred upon it which concerns the residents of a state. The union territory which is contemplated constitutionally and is contained in Part 8 of the Constitution merely represents an extension of the union, and therefore there is no concept of federalism between the union and its extended area. The union territories are retained under the control of the union because of different strategic significance of each union territory, be it defense or such other significance. Delhi has the distinct significance of being the capital. The union territory, apart from being an extension of the union, is a reflection of will of people residing in the union territory, and therefore its constitutional status is less than that of the state and more than that of the municipalities and panchayats, because they are also units of governance under the Constitution now, after Part 9 and 9E. The Constitution has therefore given a sui generis position to Delhi, being the capital of such a big nation, and has very consciously restricted its powers only to those entries in List 2, which can be applicable to a union territory. There is one only place in the entire Constitution where the supremacy of Parliament is constitutionally recognized by conferring jurisdiction even on List 2 subjects, and that is when union territories are concerned.
There's some problem with this sentence. Perhaps you'll have to recast it.
Last question.
There is only place in the entire Constitution.
There is only place in the entire Constitution where the supremacy of Parliament is constitutionally recognized. We will rephrase it. What I am intending to submit is that normally Parliament's power is List 1 and List 3.
Here it's List 1, 2 and 3 over UTs.
Yes. Yeah.
That's what you're saying.
That's what I am saying. That is the only place in case of union territory that supremacy is given even in 2. Otherwise, no other unit of governance has this provision.
Mr. Mehta, it may be difficult to accept your submission that, look, federalism as a concept applies only where the union and the states. You know, there may be also a sense of hybrid federalism where,
I bow.
where even as between the Union Territory of Delhi and the state and the center, some elements of the federal structure also apply there. May not be to the same extent as in relation to a full-fledged state. But in carving out a constitutional amendment for the Union Territory of Delhi, that was also in reflection of a certain degree of federal aspiration. So you're right. I mean, it's obviously not a state. So, you know, it doesn't have all the trappings of a state, but it has some trappings of a state. So as to implicate federal concepts, even in the relationship between the center
May I
and
rephrase my
the Union Territory.
submission? I bow down. May I rephrase my submission? Lord, the principle of federalism will not be completely ousted in the relationship between the union and the union territory. But the principles which govern the relationship between union and the state, that would not be the federalism. It would be, my lord, as your lordships have rightly suggested, a kind of a hybrid federalism with supremacy to the center and, Lord, federal structure, constitutional earmarks under Article 239.
Why do you postulate federalism? I mean, as an abstract constitutional theory. Federalism implies when you don't have a unitary form of government. That is, you have a demarcated polity where governance is distributed both in legislative and executive terms at different levels between the center, between the states, between units within a state also. So that these characteristics of federalism are prevalent even in relation to union territory. In fact, I would think that even say the panchayats, the municipal corporations, which now come in by virtue of a constitutional amendment, they are reflective of the need for local governance. You see,
Decentralization of power.
Decentralization of power.
Look, I'm not pitching my case. I make it very clear that there is complete absence of principle of federalism between union and union territory. But I'm saying the way majority considers that it is akin to the federalism between full-fledged states and union may not be a correct view.
All right.
In union territory, it would be a hybrid kind of a federalism where decentralization of power, there is no, what are the fundamentals of federalism? The federal unit is not dependent upon the federating unit, namely the state, etc., is not dependent upon its source of power to the union. Constitution is the source of power. So federalism would apply. But the nature of federalism, the threshold, etc., would be different than that of a state. That's, my lord, I'm not pitching it to an unrealistically high level.
Yes.
So you're willing to state that the boundaries will be hemmed in, but there will be boundaries where the center will keep its hands off.
Look, I would not put it, yes, I bow down to what has fallen from your right. Lord, in case of union territories having legislature, there would be a federalism. Look, there are union territories, no legislature. We directly control. There is no elected government. So there is no question of there being any federalism. But in two, Puducherry and Lord Delhi, there is a legislative assembly. The concept of federalism, as my lord, the Chief Justice of India rightly says, my lord, would apply. But the threshold, as your lord ladyship rightly puts it, boundaries would differ. It would not be all-encompassing federalism. In any case, my lord, India is otherwise also never a complete federal or complete unitary. It's quasi-federal, quasi-unitary. Some provisions are complete unitary, some provisions are completely federal in nature, my lord. So we have chosen, my lord, that model.
Yes. So let's go ahead.